So we appreciate you all.
Awesome.
And I'll let everybody introduce themselves.
Thank you, man.
Hey, don't
Cool.
Got it. And let me give you. Okay, you need this one.
All right, folks. So first of all, good morning. Great to be with you. That was an incredible conversation. Thank you for kicking us off in such an amazing way. I'm only somewhat kidding in terms of the idea of that we've literally got a bunch of lawyers and CPAs on stage right now, because there are some really important things, decisions, ultimately, that founders make when starting a company that can have massive consequence for the success of that company and for their own personal wealth creation, control of the company, et cetera, as the company continues to grow, right? And so the hope is that this conversation is centered somewhat around like, what are the essential building blocks around governance, legal structural, financial structure, as founders think of starting a company. So you're going from idea and inception to actually getting something done, like putting a company in the ground, maybe raising some money. What are the questions legally, fiscally, that founders should be thinking of in order to ensure that they're kind of on a smooth path to success for future growth? So I'm only gonna kind of provoke questions and a couple of fights. But I'd love for each of our panelists to introduce themselves really quickly, kind of name and generally what you do that makes you semi-qualified to be up here. Jason?
How you doing? Jason Stark, I'm a partner at Next Legal. We focus on business and real estate transactions, so we're a little different in that we don't go to court and sue people. We focus on helping your business. So for startups, that's getting all of your IP and incorporation documents correct. And then after that, you're going to have your Series C, convertible notes, Series A, those type of transactions. As Raul mentioned, negotiating with the investors, that's incredibly important. And then hopefully at some point your exit, which is what people refer to as mergers and acquisitions. We also work with like investment funds, so we sometimes see the perspective from the other side and what they're looking for in startups, and doing exits and those type of deals.
Awesome.
Hi, I'm Liz Flores. I'm a partner at PAG. Okay. Sorry. I'm Liz Flores. I'm a partner at PAG Law. We are also a law firm focused on business. We do have litigation as well. We are a 100% Black and Latino-owned law firm, and we're very focused on representing founders and startups. We currently represent over 300, doing a lot of the same transactions that Jason mentioned. As a minority-owned firm, we are very committed to the growth of the minority founder community because we are minority founders. I'm here with my colleague Fernando as well. We're here in Miami, but wherever you are, consider us a resource. And we hope to be of help. And feel free to grab one of us after the session too if you have any additional questions that didn't get answered during the panel. It's great to be here.
I think mine working? Yes. Okay. Hi everyone. I'm Tyler Quinn. I'm a CPA, a partner at Kaufman Rossin. It's a large CPA firm based in South Florida, and I have the honor of leading our technology group. So what that allows me to do is work almost exclusively with technology companies. Most of them are South Florida based, and I'm also heavily involved in the ecosystem. So I'm a mentor of several of the business accelerators. I also work with several of the angel groups in the area. So I'm very familiar with what's going on in the investment community and in the startup space. And so it's an honor to be here and talk about it.
Hey everybody, my name is Fernando Burman. As Liz mentioned, I also work at PAG. I'm a senior associate at PAG. And to echo what Liz said, we're a minority firm, and we assist, founders, companies to form their company, to raise money. And we, I don't want to repeat everything that she said, and what we do is also very similar to what Jason does as well. But we like to add a personal touch. We understand, the hardships of actually creating your own company, raising capital, and we understand that, as Tony mentioned, when you are actually raising money, you might have an investor that want to, get too much, and we're, actually there to make sure that you are protected and get a transaction on a playing level field.
Awesome. Thank you all for being here. So as a whole, I think in the last kind of decade in particular, there's been this romanticization of entrepreneurs, right? Who's on the cover of Inc? It started in a dorm room. It was a perfect linear path to like billions of dollars of revenue. And everyone knows that's not true. That's bullshit, right? A lot of founding teams end up in divorce, like other relationships, right? We had a great kind of first run, but then we grow apart or whatever it is. Difficult decisions have to happen. What is it that founders can do from the very beginning, Liz, to ensure that if those things do happen, those rough patches, the ups and the downs, that the company isn't frozen or stalled, right? So we talked about redemption rights earlier. What are the key elements, documents, or parts of those documents that founders should think of including into their organization docs to account for, almost like a prenup, future possible disagreements and or friction?
It really is a prenup. I get a call almost every day from founders that are arguing. Unfortunately, 80% of startups fail or more. And the majority of the ones that we see fail are failing not because of a problem with the tech or the operations, but because a dispute between the founders has kept the company hostage. So it's well worth an initial investment with a lawyer to determine some ways to prevent that from happening. One is vesting. A lot of founders feel like vesting is something that investors want, that it's not in their interest for their shares to be subject to vesting. Perfect example, we had a 3-founder company where they did everything online. They didn't want to hire lawyers at the beginning. Like most startups, they were pretty strapped for cash, which is understandable. The problem is their shares weren't subject to vesting. So a few months after they founded the company, one of the founders, one of the partners who had a third of the company, disappeared. He just stopped working, he stopped contributing. And the other guys were working day and night like crazy to build the company. When they went to investors, they have to share a third of whatever they make when they sell the company with this guy who basically did nothing. So the lesson is vesting. A lot of founders are really sort of penny wise, pound foolish when it comes to hiring lawyers. It doesn't cost anything to pick up the phone. If you call one of us, we'll definitely try to bring forth the lowest cost solution. We deal with founders every day. We know the budgets aren't high. A lot of stuff you can do online, and when the online solution is there, we'll definitely say that. When something else might be more appropriate, we'll figure out the cheapest way to do it so that you're spending your money on building your company and not on lawyers, but meanwhile protecting yourself with things like vesting. But I would say vesting is number one. Your investors will expect to see it, and it'll protect you as a founder from one of your other co-founders leaving or eventually not contributing what is expected to the company.
Fernando, same question, but somewhat in the context of what someone mentioned earlier. We referenced WeWork, we referenced Adam Neumann being kicked out, and not only being kicked out, but getting $1 billion plus exit package for essentially taking his company to the brink of bankruptcy. No comment, right? That is, in some ways, kind of a core lesson in governance, right? Investors didn't demand certain things. There were things in the organizing documents that screamed out, this probably isn't a good idea, super voting rights, et cetera, et cetera. What are, in the same context, what are things that founders may have heard of because WeWork and Facebook and other companies have done these things that are maybe non-conventional governance arrangements that they should be mindful of, right? That maybe having a founder, 2 classes of shares, one with 10x voting rights, the other not. What are some of those elements that maybe are more in vogue now, but that might actually either scare off investors or cause problems down the line?
Yeah, it is a complex question. I mean, just to touch a little bit about what happened with WeWork,
Yeah.
It's actually, when you create your company and you're going to go public, just to make sure everybody's on the same page, you actually have to file a document before the Securities Exchange Commission. Okay, and a lot of information of your company that was previously private becomes public.
Yeah.
So everything that you just mentioned basically started because of that, right? And taking a step back, I think I like to give practical examples. So just quoting a couple of things that we heard here today, I think it's important even before you have an investment, to make sure that you are transparent with the investor, to make sure that you're on the same page. So when we heard Tony and Michael talking today, we heard Michael saying that a lot of people come to him and say, "Can I get some money?" And his answer was, "Well, maybe. First, let's make sure that I, understand what you're building. What is your goal? What problem you're trying to solve?" So this type of relationship is very important. And when we heard Tony speaking today, you can see that he also has a clear message. He's trying to build a platform to solve a particular issue on the music industry. So I think an important point that I'm trying to make here is that even before you receive an investment, it is important that you make sure that you're both on the same page about your goals and what you want to build with your company.
Yeah.
And another practical example that I like to say is that, Tony, he said, we're broke, right? So this is not supposed to be a secret. It is important that you and your shareholders continue to have like a transparent relationship. So if you talk about documents, you're going to see that when you're actually receiving equity, there's a lot of obligations that the founder has to comply, such as, holding shareholders meeting, making sure that you disclose your financial statement, make sure that you share and get approval on your business plan. So if you're both on the same page from the beginning throughout the growth of the company, what we heard from Tony today is not a surprise. I'm pretty sure that if we know that the health of his company, his investors also know, and they're supporting him as well.
Awesome.